Rise. Hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within the Commonwealth. Draw near, give your attendance, and you shall be heard. Now say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone. My name is Vicki Henry. I'll be your panel chief today. My pronouns are she, her, hers, or judge. I am delighted today to be joined by Judge Hand on my right and Judge Brennan on my left. Welcome to the 2025-2026 Appeals Court year. Each side has 15 minutes per side, for better, for worse. There's no rebuttal here in the Appeals Court. I am going to predict that we're a hot bench and that we will have a lot of questions. We'll try to let you get out some argument before we jump in, but you should take that as a good sign. I can assure you, which we do every single sitting, except nobody seems to believe us, that we have read your materials, and we might in fact know your materials better than you do. So I would really encourage you to jump to the heart of your legal arguments. And I believe in this first case, there's an impoundment of the victim's name, so we don't need to, we don't need to say that name. That would be best. And sometimes, as you see here, if you see us looking at our device, it's because we do almost everything electronically here, and we have all of your papers on our devices. So we're definitely not checking the Patriot score, and we will be referring sometimes to our notes. With that, we are going to call the first case. It's 2024 P 692 Commonwealth versus Rukebesha.
Good morning, Your Honors. I do, in fact, trust that you've read the materials. No problem there. If it may please the Court, William Dolan for Mr. R. The concepts of knowledge and intent are woven through the issues presented today to this Court. And I think many of the facts and the evidence that was presented at trial relate to both. I understand that the standard of review is light, most favorable to the Commonwealth, but the analysis is more nuanced than that. The analysis does not just end at a simple statement that light is most favorable to the Commonwealth. It is what those facts mean and what the inferences can be made from them. It is not a question in this case that Mr. R did not speak the English language. That was the evidence. The officers testified that he could not speak English. The victim in the case testified that he could not speak English, also testified that she could not speak English. Mr. R could not understand the verbal orders that were given to him by the officers that night. And the police officers did do the best that they could. And there was a lot of testimony about that. And I would submit to the Court that the officers were frustrated with Mr. R and frustrated with the situation that they could not communicate with him.
So where the officer Wiggins testified that he was a patrol officer in uniform and in a marked cruiser and that he was backing up Patrol Officer Kidd, why can't the jurors reasonably infer that Patrol Officer Kidd was also in uniform?
I think that even the Commonwealth submitted that there was no evidence that
there's no question. They went through the questions as to Officer Wiggins, and they did not take the best practice approach and ask the questions about Officer Kidd. But why can't that be filled in with an inference? I agree it's not what should happen, ideally.
I simply don't think that's sufficient, and I also think it's sort of I'll use nuance again, approach, because as we see other parts of the analysis, it's what being in uniform means to Mr. R.
You don't dispute that your client understood that the uniformed officer was an officer?
I do dispute that. I think
that he actually knew that the person dressed in a police uniform with the badge and with the, if he had a bulletproof vest on, et cetera. You dispute that your client, or that a juror could infer reasonably in the light most favorable to the Commonwealth that your client knew that that person dressed in that manner, behaving in this manner with handcuffs was a police officer?
I want to be exactly clear as what I'm presenting to the Court. I think that given the evidence that was presented to the jury, specifically included but not limited to the fact that my client was a refugee, the fact that my client did not understand the English language, that there was insufficient evidence presented that the Commonwealth did prove that my client did not know that the person in front of them in what we call a uniform is a police officer or, as defined by the statute of state.
It wasn't evidence he came to the country 30 years ago?
No,
I kind of sifted through that, but or left his native country 30 years ago and has been here at least for a decade or two?
So frankly, that's not my memory. I believe that there was an issue of him being disabled at a refugee camp 30 years prior to the incident. I believe that might be what the court is responding to. I don't have a recollection of the exact time period. I do believe there was some testimony as to when they...
Maybe 9 years?
I don't think it was that... I could guess, Your Honor, but I don't think it was that long ago. I don't want to guess, but it was not... It was not 20, 30 years ago. That's at least my recollection. Obviously, the transcripts would control that specific fact as to what the testimony was. Okay. Maybe not what it means, but that would control.
With respect to Officer Kidd, I misunderstood, or I was not clear on what you meant about the inference. Let me ask again. With Officer Kidd, is it your position that the jury could not infer that your client knew that anyone there was a police officer, or that the information provided about the circumstances were sufficient to allow someone to infer that Officer Kidd could be understood to be a police officer?
My position is that, based on the facts that were entered into evidence, that there was insufficient evidence to show that my client understood that the two gentlemen in front of them were police officers.
Either one of them, and regardless...
I'm sorry, Your Honor, could you speak up maybe a little bit?
Sure. Either one of the two officers, that's your position as to both officers, regardless of who was... There was evidence of uniform in the case of one and not the other, but neither officer, from your point of view, could have been... the evidence in the light most favorable to the Commonwealth did not show that your client understood either one of those officers to be a police officer.
Yes, Your Honor, and I think the argument is bolstered. Maybe to put a finer point on that, I think the argument is bolstered for the officer that there was no evidence that he was in uniform.
So would there be any circumstances imaginable where your client, based on, as I understand it, his inability to speak English and his immigrant status, is there any set of circumstances that would have presented where he could have understood that a person standing in front of him is a police officer?
Yes, Your Honor.
Without a translation that we know about.
Well, yes, Your Honor, if the Commonwealth had presented such information.
So again, give me an example of what beyond full uniform, gear, vest, badge on my chest, what else could they have done? And verbal statements that couldn't be understood.
So there are 2 points that I'd like to make. First, I think just in this specific case, maybe not globally, but this specific case, there was a son who was translating. And the statements, no matter what language they were in, would have been...
Stick with my question, though. Stick with my question. Beyond those things that were part of the record, what more would have been necessary, or what is the minimum, or is there any circumstance under which your client could have understood that at least one of these people was a police officer?
Yes, Your Honor. I think if there had been any testimony, even from my client's wife, that he understands the cultural significance of what that badge would be, or what any of that insignia would be. There is certainly information the Commonwealth could have provided, some type of context to show that he understands what a uniform is. He understands what the normal indicia of what a police officer is. And the case law, the jury instructions are full of things that someone could infer that the person is in front of them as a police officer, but I think as applied to Mr. R, those don't have the same meanings. And I think that the case law is somewhat, I think, minimally unclear based on perhaps applying the lessons of Quantus, the laws applied in Quantus Q, or frankly, maybe perhaps this issue hasn't been grappled with the way that it should. I think it's fundamentally unfair to say to someone that is, at least in terms of what the evidence was presented, I think it's fundamentally unfair to infer that this person has an understanding based on them not being from the United States, based on them not speaking the language. So I would infer that there is evidence that could be presented to show that, but that wasn't presented here. If I may continue? Okay, thank you. So what we do have in this case is a Looney Tunes dust cloud of 3 people in a back room with no light.
Can I ask, and not to
Please.
stop you in the midst of sentence number 1 after I ask you the last question, but before they got into the back room, there is evidence that at least there was an open door and the police officers were standing in a not dark back room. Is that fair?
Correct, and my client was found not guilty of the charge of shutting the door on the police officer.
But in the context of what your client could see or perceive or understand as far as who was there and how it transpired, right? There was at least some evidence that his only contact was not in a darkened room with these 2 people.
Oh, I agree with Your Honor, and I think, and again, I think in terms of Your Honors have read my briefs, what I'm attempting to do is I think that many of the evidence that comes in is, as I stated, is relevant to knowledge and intent. So maybe perhaps this could be an example where what I refer to as the Looney Tunes dust cloud may be more relevant to the assault and battery and police officer charges that were to have alleged to come out of the bedroom. And just a point on that, the testimony that came in was the police officer could not remember where I think that the term was successful headbutt, if it was either in the kitchen after the fracas in the bedroom or in the bedroom. So in terms of the back bedroom, which is the source of the assault and battery charges and I believe the resisting arrest charge, is that it is a back room without any light. There is certainly a fracas. They go from seemingly in the doorway to, and it's not particularly clear, but what I think you can be gleaned from the transcripts is that it starts in the doorway and at some point gets onto the mattress, and then at some other point ends up on the floor. At some point after the incident occurs, my client went to the hospital as the police officer testified that I think it was he quote-unquote bumped his head or hit his head. So what we have in the back bedroom, even the testimony of the officer was unclear. He can't remember at what point there was a successful headbutt, whether or not it's in the bedroom or in the kitchen later.
But the testimony was it could have been either one from the officer's point of view, correct?
Even if that is the exact words, I still would submit to the court that what he's saying is he doesn't know. So this is important because of the analysis of, well, intent and knowledge. Assault and battery is a general intent crime. That is correct. But it has to be proven that it is not just merely accidental. When you have a fracas like this, and I'm not even quite sure if the police officer could testify definitively, and again, I understand that it is light most favorable to Commonwealth, but even from the testimony, I don't think that it can be inferred that many of the blows that he's describing aren't coming maybe from the other officer that's present there.
There's also a reckless theory, right? I don't know if it was part of this case, honestly. I don't remember, there was no instruction. Was there instruction, actually? I shouldn't say there wasn't.
Your Honor, I'm not sure of that issue.
Okay. Can I ask you a different question about intent?
Yes, Your Honor.
In your brief, you say that the bare statement from the victim that he hit me was insufficient to establish intent. But it seems to me that right after that, she says, he punched me right here, my eye, and another one with a fist. Isn't there a qualitative difference between hit, which may or may not be more easily accidental, and punch with fist, which seems to me in my experience would be seldom, or at least an average juror might say would seldom be accidental?
I think that if we take these statements, it is fair that they must be taken as a whole. I mean, they are back to back. I would say that they are bare assertions, and I think if we look at, although slightly different, if we look at the Hart case, you can't just say someone assaulted me. I understand that's not the issue here.
Well, but then when you have a swollen eye that you can't see out of for a week, that would seem to me to take the bare away from the assertion and put it maybe in the corroborated, supported assertion? Why not?
So I think that, frankly, I remember an example from law school, actually, in talking about, I believe it was towards class, when I went to Suffolk, not very far from here, and the example was that on the Green Line on the way in today, the professor was assaulted by the other people on the train, and that when, and I think we've all probably been there, many people, for example, being pushed into the train car and maybe going over a bump or having to stop a little too quickly on some of those interchanges on the Orange Line or the Green Line. So I would present to Your Honor that that still stands here, and that the statements that were made fall into that type of description.
It seems to me, though, she's testified that the defendant punched her at least twice in the face with a closed fist. So I don't understand how that's insufficient to establish the intent element of assault.
So, Your Honor, I understand the court's position. I would simply disagree. I think that based on what the evidence that was provided, that it was insufficient to prove assault and battery.
So back to Officer Kidd for a moment, you argue that Commonwealth couldn't prove he made contact with Officer Kidd during the struggle. The Commonwealth responds that Officer Wiggins testified the defendant was pushing and shoving both officers while they tried to restrain him. Why is that not sufficient?
Are you asking about the testimony from the back bedroom or a testimony?
Yeah.
Okay.
I think that's around the back bedroom. Back.
Correct, Your Honor. That's my understanding. So I would repeat the same arguments that I made earlier. I think that given the fracas and given the testimony that came in, especially where Officer Kidd, it wasn't the officer that testified, that there was insufficient evidence to prove that my client, even through those blows, based on the dust cloud that was described in evidence.
Right. That is the end of your time. I think we understand your arguments, and we'll hear from the Commonwealth.
Thank you, Your Honors.
Good morning. May it please the Court. Hallie White-Spade, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The evidence was sufficient. The question before this Court is not, did the jury get it right? Could the jury have found otherwise? The question before this Court is, was there enough evidence to allow the jury to consider these charges? The victim testified he punched me with a closed fist several times. That in and of itself is sufficient. There was no question that she was his wife. There was no question she was over 60. She testified.
A question on
yes.
Just a technical question, because there's some indication that the case is impounded. I don't see any charges here that it seems to me would require impoundment. Maybe the technical. Why is the case impounded? Why is the name impounded?
Oh, I think because one of the charges is sealed because he was found not guilty. I think that's my understanding.
Okay.
The new rules on sealing are baffling all of us, Your Honor.
All right.
Yeah, no, it's not. She's not a sexual assault victim.
Not a sexual, and it's not a 209A?
No.
And there may have been one at some point, but this is all.
I don't think.
Okay.
I don't think there was anything in the record about a 209A.
And your brief actually uses the name.
Yeah. And I followed what was on the appeals court's online docket, which used the defendant's name, and I saw no statutory or rules-based reason to not use her name. So, but I'm happy to say defendant and victim because I get confused anyway.
Just one other housekeeping matter. Do you agree the appeal was timely filed?
I agree that this court allowed it does appear to have been beyond a year. So, yeah, I noticed that, I think, too late. So, I'm willing to, it's been fully briefed, it's been argued, but that is an issue. Because, yeah, I think that, but no, actually, and I did think about this yesterday. There was apparently, the notice was filed but not docketed. So we could have an argument about where the court accepted that it had been filed, but it somehow didn't get in the docket.
Is the Commonwealth arguing about that?
No.
Okay, thank you. Focusing on the identification of Officer Kidd as a police officer, do you agree that there was no direct evidence that Officer Kidd was in uniform or in a marked
That's
cruiser?
correct. There was no direct evidence. Officer Wiggins testified in great detail about his own uniform and that he was there to back up Officer Kidd. Even if Officer Kidd was in plainclothes, and you don't have to be in uniform to be identifiable as a police officer, it was clear they were working together. The idea that this defendant, even if we grant his representation that he spoke no English, hadn't been in, and by the way, there is nothing in the record as far as I know about how long he'd been in this country. He didn't testify to that, and there seems to be some evidence about the son having been here for some years. He testified about some ongoing conflicts, but he did not appear to have just gotten off the plane.
So why shouldn't we hold that the Commonwealth had an obligation to affirmatively introduce any piece of evidence that Officer Kidd was an officer?
Because we take the evidence as a whole. I think that's the answer. We look at the evidence as a whole. We look at reasonable inferences from the evidence. And that's why.
And in taking the evidence as a whole, do we consider the defendant's potential lack of cultural familiarity with the practices of the police here?
I mean, that's a factor. We are not, because we take the evidence in the light most favorable to the Commonwealth, we are not obligated to accept the defendant's hypothetical version of his recognition or non-recognition. And again, while it's not relevant to the sufficiency of the evidence at the close of the Commonwealth's case, I do note that the defendant himself testified there were two officers. And he never says, I didn't know they were police.
But that doesn't help us when we're just looking at the Commonwealth's case.
Not relevant to the Commonwealth's case. It's certainly, where there's an argument that the Commonwealth's case deteriorated, that is certainly relevant. In fact, the Commonwealth's case was bolstered by the defendant's case here. But it's a reasonable inference that where two people are working together, one of them has a badge, a patch, and a pair of handcuffs. Is there an alternate explanation for that where that's not a police officer? Sure. We are not obligated to disprove that. And again, it's in the light most favorable to the Commonwealth. And the son was there translating. There appeared to be no problems when the son was translating for the mother. And this supports an inference that Officer Wiggins testified, it's around pages 69, 70, 71 of the transcript, that they were telling the defendant through the son, with the son translating, that he was being placed under arrest.
But the defense implication,
successful.
the defense implication seems to be that there was some familial division, that the son had sided with the mother, and so he really could have, for all we know, set up the father by not properly translating just for the father.
Again, that's an alternate inference that is pure speculation with absolutely no evidence to support it. What we have is successful interpretation for the mother and absolutely no basis, let alone a basis that lets us keep taking the evidence in the light most favorable to the Commonwealth that would allow us to say that.
So assume for a moment that a defendant does not speak a word of English, what's the, can he still be arrested and convicted for resisting arrest? I mean, I think your answer is yes.
Yes.
And could you just fill that in?
Badge, patch, handcuffs, police vest, son is translating and being told that he is being arrested. That's sufficient.
What if we take out the son as telling him he's being arrested and we're just left with the uniform, the police car?
It's a little closer, but I think in the again, in the light most favorable to the Commonwealth, I think could a jury go into the room and say, he's a recent immigrant, I don't think he knew he was a police officer? Sure, they can do that. The question here is, do we even allow them to think about it?
I guess what I'm trying to understand, though, is where nobody said the son accurately translated Can we even consider that the son was translating? Can the jury consider
Yes,
that?
yes, you can, because there is testimony that when the officers arrived, the son was translating for the mother. And there's no testimony that there was any, either from the officer or from the victim, that there was any difficulty with that.
With
And that
respect
supports
to-
an inference that it was also accurate for the father. Could there be a case where that is the make or break question? Sure. I don't think this is it.
With respect to the victim's injuries,
Yeah.
is substantial impairment a question of fact or of law or a mixed question?
That's a good question. I mean, I think it's a question of fact,
Okay.
which means it goes, it's something that you consider in a sufficiency analysis.
And your argument is what injury or injuries in the light most favorable to the Commonwealth get you over the threshold from a mere injury to a substantial injury, or a substantial impairment, I'm sorry.
I think, I mean, and again, it's bodily injury, not serious bodily injury.
Yep. Which would be
I
different.
think, I
know.
think the eye swelled up immediately so that she couldn't see out of it. She had to go to the hospital. She couldn't see out of it for, I think she said, for a week. She was still having problems with her vision at the time of trial. That's so far over the threshold.
Okay.
And the cases that the defendant cites, there's one where the child's ear was bruised. And there was no evidence that interfered with any bodily function. And that was the only injury that could be proved to have been intentional. It's simply, this is simply not that. This is so far beyond any of those other cases. The resisting arrest, I just want to note, the Hart case on which the defendant replies is utterly irrelevant here. Hart is a plea case, and the question was what's a sufficient factual showing to support the plea, and the officer or the recitation of the facts by the prosecutor in the plea hearing was he resisted arrest. And the SJC quite correctly said that's not sufficient to establish a factual basis for the plea. Absolutely irrelevant here.
So the defendant argues that the basis for the assault and battery charge on a person over 60 with injury was the hit to the eye, and then says the basis of A and B on a household member was the hit to the forehead. Do you agree with that? Does that matter?
Sure, I don't think it matters. There was no specific unanimity requested, and I don't remember specifically what the instruction was.
There was no.
Was it not distinguished in the instruction? She testified that he punched her 3 times, but I think that the eye and the forehead were the ones that were most prominent in the evidence. But again, there's nothing about that was raised below or on appeal. If there are no further questions, I'll rely on my brief and ask the court to affirm the judgment. Thank you.
Thank you very much. The case is submitted. We understand your arguments. Our second case today is 2024 P1064 Commonwealth versus Bombas. We'll hear from Attorney McNaught first.
Good morning, Your Honors. May it please the Court. Teddy McNaught on behalf of Helen Bambus. Your Honors, General Laws Chapter 90C, Section 2 requires police officers to provide a copy of a motor vehicle citation to a violator where and when the violation occurs, unless one of several exceptions apply. The exception relevant to this case is whether the circumstances themselves justify the officer's failure to cite Ms. Bambus. There is no dispute in this case that Ms. Bambus was not cited by the officer on the date in question.
Can I ask you a couple of questions just as sort of to set the stage here? Can you tell me first what your understanding of the standard of review that we apply, not to the findings of fact, but to the legal conclusions?
I'm arguing that this case should be viewed almost as a strict liability case, where if the service wasn't achieved in the moment, then the outcome, that determines the outcome of the case.
Are we looking at that de novo, or are we looking at that as an abuse of discretion? How do we treat it? I think the Commonwealth says abuse of discretion. I don't know what your view is.
I think I misunderstood the court's question. I apologize. I advance a de novo review in this circumstance.
Could I ask one other question? As far as I understand it, you challenge one set of facts as, findings rather, as clearly erroneous. Is that correct, or are there more clearly erroneous facts than?
I think the court's referring to the finding relative to the pandemic.
Correct.
As to the rest of the record, I think the facts, as the court found them, were to some extent ambiguous, but otherwise reliable and did not provide or do not provide the basis for the clearly erroneous argument that I do attach to the COVID finding.
Thanks.
So with respect to the circumstances of this case, Your Honor, there are a few things that must be highlighted. First of all, the nature of the initial investigation. It involves a single car accident where ostensibly there are no serious injuries. That places this case along, I would argue, the beginning of a spectrum of cases where we go from, I would say, this case, one extreme, to a fatality, or the Kenny case that the Commonwealth references, where a person's thrown in the air 40 some odd feet, or the Perry case where fatalities are present. So the nature of
Excuse me 1 second. You argue both under the no fix and on the notice. Is that right?
that is correct, Judge.
Let me start with the no fix. If the officer's handing a citation that has been prepared to someone on the scene, what's the opportunity then to go fix the ticket?
Right. So
Any case that's remotely close to that on the no fix end of the spectrum?
So handing the citation, or upholding a situation where the citation is handed to someone on the scene, I would argue materially changes the statute itself. The legislature selected the violator as the person to whom the citation must be issued. To insert, as here, the husband, I would argue, leads us to a slippery slope where would it be okay for a cousin, nephew, and a neighbor?
Well, that's the question, at least as far as the no fix aspect of it. Because, right, the idea of the no fix is that, holding it back in the back office and waiting for the phone calls to come in and maybe the bag of cash or who knows what else, right? But if you already handed off the ticket and it's already written out and done, how does that scenario evolve?
Sorry, Judge, the anti-manipulation, my head component of the purpose of the statute, yeah, I think I would have to concede that that's really not, that probably wouldn't be implicated by handing the citation to someone else.
And then one other question just before and I'll let you get back on your roll, is I don't think either side addressed it, but to the extent that the officer knew of these parties because there were some reports of domestic violence at the home, does that in any way impact the husband's role as the agent of the wife, or do we need more information, or one way or the other, just on this record? Right.
So I would argue we need more information first and foremost. It's not well developed, but it does open the door. And the court's, I would use the court's example. What if this is a situation where the officer was familiar with the couple through a domestic violence history? Well, then does that make the husband a capable agent for his wife in this situation? I would argue it doesn't. And I would add that it's not on the officer to designate an agent. It would be on the violator themselves to say it's fine to give this person can act in this situation as my agent, but the case here didn't provide any facts that would allow us to reach a conclusion that Ms. Bombas herself said, yeah, give it to my cousin. Had the officer, I think, went to the entry of the ambulance where Ms. Bombas was being treated, as he could have, and looked in and said, hey, can I give this to your husband? Well, we'd be dealing with a different case. But the officer made that selection on his own.
But that isn't necessarily a dispositive factor. in the analysis that you're suggesting. There are other cases in which the police have, without approval of the defendant, provided a citation to someone other than the defendant, for example, the defendant's father, correct?
If I may, yeah, so the Perry case, Your Honor, that's right, but Perry is so different than this case in at least two ways. Firstly, the Perry case involved a fatality, and the officer in Perry went to the hospital.
Okay, but different circumstances. It wasn't COVID during the time that Perry was, the facts of Perry were taking place, correct?
Absolutely, Judge. But the officer here never tried, and I think that's a major deficiency in the state's argument that and the basis for what I would say is the clearly erroneous finding by the court. If had the record indicated that the officer went to the hospital and made an attempt to access, to interface with the defendant, we'd be dealing with a different case, at least a case that would be closer to Perry, because we know in Perry that was an effort that the officer made. Here, no effort or attempt to actually get into the hospital was sort of a shorthand assumption that he wouldn't be allowed to do that.
But there was testimony saying it was COVID lockdown. It was more than just an assumption that he wasn't going to be able to do that, and I think that's something that historically isn't improbable.
That's a
This was 2 months after the lockdown began, correct?
very early on in COVID. Yet, Your Honor, it's interesting because also in the transcript, the officer says the only people who were out and about was essentially fire, EMS, and first responders, like us. So I would argue if anyone was going to be given access to the hospital, it wouldn't have been Mr. Bombas, it would have been the officer himself, because they were out, but they had to be, right? That's the nature of what they do.
So the officer should have taken the risk that he would not have been admitted into the hospital, reserved the citation to try and deliver it that way, and run the risk of not being able to deliver it, rather than handing it off to the defendant's husband on the scene? In her presence?
I think I understand the question, but
That's a great question. I'm impressed if you do.
The main point, though, is yes, I think he should have gone to the hospital and at least made an attempt, because the statute doesn't say it's okay to serve somebody else. It says the violator. That's why these officers in these cases are focused on, in the cases, the analysis themselves, focus on how and when the violator was served, except for, I think, the only two public cases, which is the Perry case, a fatality, non-COVID for sure, but very, very different, and the Gendron case where the violator was standing next to the spouse. That's not the situation here, where Ms. Bombas was 20 feet away, according to the record.
But here, he was engaged in speaking with her, and at some point she indicates she does not want to talk anymore. And she's now at the ambulance receiving some attention, right?
So, Your Honor, I would classify her engagement with the officer as more as dismissive. I don't think she terminates in the way we think of that in the context of a Miranda interrogation or something like that. She doesn't really engage with the officer at a level that the officer would want her to in order to investigate, to answer specific questions directly, and so on and so forth. But, Your Honor, she's conscious. And I think the fact that the officer characterizes her as agitated, I think he uses the word abrasive in dealing with the ambulance, really opens the door for him to at least engage with her, or continue to try to engage with her where he didn't, and say, this is for you, as she's on scene.
Well, if he had, let's assume for a moment she had a purse, I don't know whether she did, and he had walked over and just put the ticket in her purse, would that have been sufficient?
So I think I'd still be arguing that it's insufficient, but I think we'd be the state would be in a better position, for sure, if he went to the ambulance and at least gestured. I mean, there are cases, Your Honor, where the violator has been informed directly, you're going to be charged. Here the charge is coming, and this is the nature of the charge. And that still was insufficient in cases like this, where the accident doesn't confer notice by virtue of its seriousness. This is a situation where Mr. Bombas on the record said, she left the house and appeared to be fine to me. It's not well developed what was going on with Ms. Bombas, why she was, we could say, emotionally distraught. Obviously, the officer had his suspicions.
Is this, from your perspective, I mean, you may have said it at the outset, a strict liability on the notice issue? Either you gave the notice or you didn't, or do we look at the reasonableness or lack thereof of the officer's choices? and methods of delivering notice or service.
So I think that the law in this context, specifically when we're dealing with a minor motor vehicle accident, says practically this is a strict liability. If you do not comply, prompt and definite notice is the touchstone of the statute, and strict compliance is what the cases say. So strict compliance, prompt and definite notice in a case like this, I would say is reasonable. We shouldn't go to reasonableness. I think that's a reason too why judge prejudice doesn't matter so much here. The flexibility, I think, would increase as a matter of degree when we move up the severity of the accident. But as we are down this end, case like the Ray case like, Burnham, and the recent SJC case, O'Leary, there are decent reasons in those cases why the officer didn't follow the statute, strictly speaking, and those reasons didn't save the Commonwealth. I would argue the circumstances here shouldn't save the Commonwealth either.
So if the officer had held up pointed at her, held up the ticket, and then pointed at the husband and handed it to him, would that be enough?
It would certainly do a lot more for the Commonwealth by at least saying, this is signaling her, there's something I need to be aware of. Here, what the officer did is he transferred a legal obligation, which the statute confers upon him, that is significant. It says there's a process here, it's a formal process, this is the order you must follow, okay? And he basically said, you do this, right? I mean, you take care of this without any conversation. That's an important distinction. No conversation whatsoever with Mrs. Bambus on this.
But the problem with the strict liability argument, it seems to me, is that the statute itself says you must do these things, and I agree with you to that extent, unless one of these three circumstances is true, and one of them is if there's a circumstance not inconsistent with the purpose of the section that justifies the failure. So it leaves a catch-all, as I think somebody called it somewhere along the way, provision in there. So I'm not sure is that inconsistent with a strict liability theory?
So the catch-all really gets its traction, Your Honor, when the accident itself is severe, and I would argue the violator has, in effect, implicit notice of what's going on.
But if that's what the legislature meant to restrict it to, couldn't the legislature have said that? And it didn't?
Yes, Your Honor. Yes. And the legislature has yet to, the statute's been on the books for 50-something years, the legislature has yet to say, agent, husband, wife, it says the violator. So obviously there is some flexibility here that it's on the courts to resolve. But we are in this particular case in the least flexible realm when it comes to the facts and the lack of injuries in the accident. I would, with time I have remaining, want to emphasize one of Her Honor's points about the pandemic. And I think there is some ambiguity in the record, but ultimately the parties have sort of settled on a version of the facts that says, Mr. Bambus was handed the citation while Miss Bambus was in the ambulance 20 feet away. So to that extent, if that's the record of this case, well then the whole COVID thing really doesn't matter. And I would suggest that it is a red herring in the context of these facts, where if the parties agree, and the best version of the record is that Miss Bambus was still on scene, she wasn't rushed off for emergency treatment, well then he didn't need to deal with the hospital, didn't need that kind of an attempt, just could have walked over.
What if he looks over, because I do believe there was something in the record about her being, whether it wasn't volatile, but what are the words? She's being difficult with the EMTs. So what if he looks over and says, okay, I think she's drunk, she's being a little difficult. Am I really going to walk over there and try and shove a citation on her, or her husband's right here? And is that reasonable?
Well, for sure it is more expedient, and I've tried to consider what I would have done in the circumstances, Judge. I can't blame the officer in that sense for making that choice, but that's exactly where the statute, that's exactly what the statute says isn't allowed. So thank you very much. See, I'm out of time. I rest on my brief.
Thank you very much. We'll hear from the Commonwealth.
May it please the Court, Carolyn Burbine for the Commonwealth. It's the Commonwealth's position that the failure to give the defendant the citation and to instead give it to the defendant's father fit the third exception of the statute.
Husband,
the catch-all.
right?
I'm sorry.
Husband.
Husband. What did I say?
Father.
Oh, my goodness. I have Perry in my
It's the
mind.
Perry.
I apologize.
That's okay, that's the Perry case, and it's, hey,
Yes.
it's our first sitting in September, so we all give you a mulligan, keep going.
I appreciate it, thank you. It's our position that the circumstances here weren't inconsistent with the purposes of the statute, and therefore, given the unusual circumstances of COVID, the officers' activities were reasonable under the circumstances, and that the judge's finding was based on the evidence, and it was correct.
So you just heard the defendant argue that the pandemic really is a red herring here. She was sitting up at the ambulance, maybe arguing with the EMTs, and the officer could have just walked over and handed her the citation.
I would point to the Perry case and say that in that case, the court deferred to the officer's decision. The nurse had told him not to give it to the defendant. The father had said, please don't go see her. She's in an agitated condition. And the court held that out of consideration for her condition, the delivery was reasonable to a surrogate, to the surrogate or the stand-in, which was her father. Here we have the defendant. She's in her car. She's crying. She's upset. She's calling people. She won't get off the phone when she's talking to the officer. She eventually tells him to stop. She's telling him, wait a minute. She's not responsive. He's trying to ask her questions. She finally tells him to stop asking her questions. And if I remember correctly on cross, defense counsel made a point of asking, so she basically told you to stop talking to her, yes. So then the ambulance comes. He asks her to turn off the car and give him the keys, and then the ambulance comes.
So can I ask you the same question I asked Attorney McNaught, which is whether the officer's testimony that he was familiar with the parties, at least in part, the father he knew from school, but he knew them because he went to the house a bunch of times on domestic calls, whether that in any way ought to factor into our analysis of whether it was reasonable to use the husband and presumably the offender in the domestic violence relationship, or even if not the other way around, as someone who was a reliable person to hand off the citation to?
Well, I would say no, because we don't know enough about the domestic violence component. We don't know whether he was the victim of the domestic violence or she was the victim, or if the calls ever turned out to even
Do we know
have any evidence of domestic violence. I'm sorry.
Oh, no, that's okay. No,
And then what we
fair.
do have is she's calling someone on the phone, she's crying, and he's the one that comes to the scene. So inferably, she called him.
What about
So
the simple angle, which is walk over and hand it to her?
Hand it to her.
Yes, why not?
She has told him to stop talking to her. She's in the ambulance.
Yep.
She was very upset when he arrived. We have testimony that she was quote-unquote abrasive and agitated, and it just made sense. He's still trying to develop the evidence too. He's trying to figure out why she's not coming up with a license. So he's talking to the husband anyway. And it makes sense that during COVID, when people are trying to minimize contact among, groups of people, first responders are the front line. They want to minimize contact with each other. Should he be diving into an ambulance with the EMTs in it and the victim when we're all supposed to be staying away from each other? There are lockdowns. He's exposing himself. He's exposing them. COVID really does play a very important part in this decision. And she's not going to be receptive. And I would say it was important in Perry that they noted that the police were respectful of the agitated condition of the defendant. And I would argue under the COVID circumstances, she's agitated, all of that would fit, that this was reasonable to give it to the husband.
If we took COVID out of the picture completely, would it have been sufficient for the officer to have served the husband effectively?
I would say yes under Perry, because again, abrasive and agitated, and in Perry, the only impediment seemed to be that the defendant was in the hospital in an agitated condition. This woman's in an ambulance in an agitated condition, and she's being brought to the hospital. So, but I would say that COVID strengthens this.
Is it significant, though, that in Perry, wasn't it a young person who probably killed somebody? I mean, this woman is agitated, but that's a different level.
But I don't, I read BAB, I'm sorry, not BAB. There is one case that I cited, it is BAB, that talks about seriousness being a factor, but it's still not, I would argue that this Perry-type situation isn't limited to only serious cases. The circumstances, it's whether there's a circumstance that justified the failure to 100% comply with, giving it to the defendant at the time and place. And I would argue that COVID and her level of upset and agitation combined put that squarely into that kind of a circumstance, even if there was not a serious accident. And I'd also add that the husband said that she saw him get the citation, and she asked him about it. So she saw it, so she knew, she was aware. And I would think that should be added to the mix as well.
Could I ask, with respect to the COVID information, I see that there's testimony in the transcript clearly about the interpretation, I understand, is open to some debate between the parties, but there's testimony about why the officer didn't go to the hospital based on COVID concerns. COVID is clearly in the background of all of this, but it's not explicit, or is not, as I recall from the transcript, brought out with respect to the officer's interaction or lack of interaction with the defendant at the scene while she's in the ambulance. So the point you made a minute ago, this is the longest question in the world, but the point you made a minute ago about the fact that the officer couldn't reasonably be faulted for failing to insert himself into the treatment that was going on in the ambulance because in COVID circumstances, one didn't. How do we get to that on the transcript that we have here?
I think that's a reasonable inference. I mean, he talked about, where we were in the midst of COVID, the government had lockdowns, there was very, very restricted access to hospitals for police. Really, the only people that were supposed to be out and about were emergency personnel.
So why isn't
think
the
it's-
converse then not true, which is, I'm not going to be able to get it at the hospital, so I better hand it to her here, and she's 20 feet away.
But he
And I've already
has,
interacted with her, so to the extent that we've exchanged air here, that's done. Check that.
right. I understand the court's point, but I still disagree where he has a reasonable substitute standing right here. She's cut him off. She's abrasive. And COVID, I mean, just because emergency personnel are doing their jobs, that still doesn't mean that they should have to expose themselves even more to other personnel and vice versa.
So I guess, that, I guess, still doesn't answer my question as a matter of law, which is whether, well, there's a reasonable alternative, so take your choice, take your pick. Is that what the law is, or is the law you're required to hand it to the defendant unless I suppose it's impracticable, and then you can choose a reasonable substitute or surrogate or stand-in?
Well, I mean, Carapellucci says that there can be cases that involve a mere flaw of detail that may be overlooked, and as a result, technical errors can be excused. And that's where we are here. This was a police officer made the judgment under the circumstances. COVID's an extreme circumstance.
So maybe that brings us back to Justice Hand's original question on some level, which is, what's your perspective on the standard review? Are we doing this de novo, or are we looking at what the judge did in determining whether there was clear error or an abuse of discretion?
I believe that you look at the judge's decision on the motion to suppress and accept his
It's a
finding.
motion to dismiss, though, right? It's a different standard than a motion to suppress.
But I would argue that we would, well, they're either standard, even if I'm incorrect, motion to dismiss, I'm sorry, it's a motion to dismiss. And under the motion to dismiss cases that I cited, this court is to accept his findings in the absence of clear error and not disturb his ruling, but
Those findings
for
of fact or
clear
rulings
abuse
law?
of discretion. And if I'm incorrect, I would still argue that strict liability is not the standard. It's, reasonableness under the circumstances. Look at Perry, look at Carapellucci, look at Rousseau, cases along those lines where there were technical errors that were excused. And I would argue that COVID is probably the most extreme, one of the most extreme circumstances you could have had, and that the judge's ruling was correct. Does the court have any further questions? Thank you, Your Honor.
Thank you. That case is submitted. What was supposed to be our third case has been continued to another day, so we'll start with our civil list, and after this case, we'll take a mid-morning recess. Case 2024 P720, Filzer and others versus PITSICK LLC and others.
May it please the Court, Your Honors. Thomas Moriarty for PITSICK LLC and Stephen Petrowski. It's the defendant's position on appeal that the judgment of the trial court should be reversed, the case dismissed, or at a minimum, the decision vacated and the matter remanded for trial. The principal issue on appeal, Your Honor, relates to the settlement agreement and its enforceability. And it's the defendant's collective position that the settlement agreement is unenforceable due to impossibility or at a minimum frustration of purpose.
So counsel, I couldn't tell what you thought was impossible or impractical to perform.
The creation of legal lots that allowed the issuance of a building permit and a certificate of occupancy for a building on lot 109 and the continued viability from a zoning perspective of the structure on lot 110.
The structure on 110 was there to begin with, wasn't it?
Yes, but it would be rendered invalid from a zoning perspective if the re-subdivision were affected as contemplated by the plan attached to the settlement agreement. The
How
reason
at this point
being,
would that be challenged, though?
I'm sorry, Your Honor?
So how at this point would that fact be challenged? What would be the, if that were true, what difference would it make if the appellate periods for all of these decisions have passed?
Well, because the appellate period for a special permit doesn't validate if the missing relief were a variance. So the mere fact that a special permit was applied for does not change the fact that the lots would remain illegal from a zoning perspective. There are 3 lots that existed historically, lots 109 through 111, each of which had 5,000 square feet. What went to the appeals, went to the land court initially, so this would have been the decision which precipitated the land court 2 decision, was whether or not a ZBA decision issuing a special permit with regard to lot 110 was valid. That was the issue that was before the land court. No party contemplated a circumstance where a decision from the land court would render the subdivision contemplated by the settlement agreement illegal from a zoning perspective.
Can I take you on that one? I'm trying to frame this question as succinctly as I can. But in my own simple way, here's how I see it. You have 2 parties that enter into an agreement that anticipates pretty much everything that may have occurred here. They minimize their risk on either side by entering into an agreement. Then they decide not to tell the judge, who spends a fair amount of time, it seems to me, writing some findings that shouldn't have had to be written. And then once the findings tend to favor one side, they try and welch on the deal. So tell me what's wrong about that statement of simple statement of how this is framed. I just don't see it any other way.
Certainly,
so
Your
help
Honor.
me out.
Certainly, Your Honor. First of all, there were 4 parties. There were the abutters, there was the bank, there was Schreiber, and there was the LLC. Okay. So those 4 parties enter an agreement. That agreement clearly contemplates a subdivision of land. So lots 109 through 111 would be subdivided into 2 lots, lots 1 and lot 2. Lot 1 comprising of 8,000 square feet, lot 2 comprising of 7,000 square feet. The issue that was before the land court related to the legality of the ZBA's decision with regard to lot 110. The interest of the abutters with regard to that appeal would have been, if they were successful, establishing that there was only 1 lot, and really 110 would have been the only house that could have been constructed. The interest for the LLC before the land court would have been an outcome that there were 3 buildable lots, all 109, 110, and 111.
Everybody knows that going into the deal?
Yes.
The agreement, right?
Right.
Okay.
So
all right.
what they...
Let me take a pause and digest. Got it? Yep. Okay.
So what they agree to is a deviation from either approach.
So what they agreed to is create a wholly separate lot, or two entirely different lots. But it's clear, it's even admitted by the abutters, no one contemplated that the decision on the ZBA appeal would be anything other than a thumbs up or a thumbs down with regard to the issues that were presented to the land court. What the land court decided was something different than simply a thumbs up or a thumbs down with regard to the issue that was before the ZBA. What the land court decided was that Lot 109 was independently buildable, had been grandfathered.
Why is that not a nullity based on the agreement, which says that the agreement shall supersede and force in effect any judgment or order issued by the land court? Why doesn't it make that an utter waste of time by the land court judge to begin with and a legal nullity secondly?
So what the parties can't do, Your Honor, is decide that they're going to supersede the land court in a way which is inconsistent with the legal reality established by the land court.
Well, that's exactly what they did do. I mean, that was exactly what the agreement did, was say that we're superseding what, and for reasons that are I'm not clear on, maybe there is one, they allowed the land court matter to proceed while they went through with the portions of the agreement. Why isn't it a calculated risk that the LLC parties were going to end up with property that was divided in a way that they agreed to under the terms of the agreement with the abutters, but that had some negative ramifications for them further down the line as far as, I don't know what, but saleability of the property or developable, whatever it might be. But that was, why wasn't that a calculated risk that they took based on the way you structured, or they structured the agreement?
The calculated risk was that either party would be surrendering the potential upside of the land court's decision.
Right.
That is, it could be one lot or it could be three lots. The record is clear. There's an admission by the abutters that no one ever contemplated what the land court would do would be to invalidate the plan that was contemplated by the settlement agreement. So to say that there was an assumption of risk, there was assumption of risk by both parties because they were giving up what could be the potential upside of the land court's decision. Had the land court decided that there was one lot, the settlement agreement would have superseded. Had the land court decided there were three lots, the settlement agreement would have superseded. The settlement agreement can't possibly supersede the land court's decision on the law with regard to the legality of the contemplated undertaking. It's clear that all parties contemplated that these two lots would be legal at the end of the day. The only way the abutter gets paid is if you can get a special permit and you can get a certificate of occupancy on a legally existing two-lot subdivision. That's the only way they'd get paid. So clearly, even the abutters contemplated that the plan that they had agreed to would result in two legal lots. No party anticipated that what the land court was going to do was to invalidate the very foundation of this agreement. And to suggest that it was just the LLC that was accepting the risk ignores the record. Schreiber accepted the risk. The bank accepted the risk. For the trial court to have concluded that the LLC could have accepted the risk for the bank or for Schreiber is not supportable. The fact of the matter is—
Counsel, judges do, frankly, often come up with a conclusion that is different than what the parties contemplated, and this agreement intentionally said, we know this land court decision could issue, but we're entering this agreement, and we're making this, your client agreed it was making this payment.
It is
why is that just not a risk that you assumed?
Well, first, to take them in reverse order, this payment, Your Honor, was necessarily contingent upon the issuance of a building permit and a certificate of occupancy.
But your clients got that permit, right? They got that. They may not have used it, but they got it. Let's break it up. Did they receive it?
A special permit, yes.
Right. And then they chose not to use it, and they proceeded under the land court decision, right?
No.
Didn't they?
In fact, nothing happened with regard to the subdivision.
How did your client, there's a house that is on what was lot 109, right?
There is, Your Honor.
that your client built?
Yes, Your Honor.
And what was the basis for it building that, or at least not having to tear it down?
Yeah, it was another building permit. It was not a building permit pursuant to the subdivision of these two lots.
Right, but that was your client's choice, right?
Your Honor, right now, presently, the lot's illegal. That was, the structure was already built. 109 then gets built on a lot that the land court determines is legal. 110, lot 110 would not be valid. The LLC sold lot 110 to Schreiber and Orbello. So the question is not whether or not through some alternate process other arrangements were made after this settlement agreement fell apart. The question is, was the trial court correct when it concluded on the one hand that the LLC's motivation with regard to its refusal to subdivide was somehow an impermissible repudiation, a breach of contract, and a breach of the covenant of good faith and fair dealing, when Schreiber and Orbello, another party to this agreement, did not want it, repudiated it? Yes, Your
That's your
Honor.
question. So the land court judge issues this ruling, correct?
Yes, Your Honor.
Assume for the moment that the matter is voluntarily dismissed by both parties, okay? So there's no longer a lawsuit in the land court. What effect does that land court decision have on anything or anybody?
The land court judgment issued, Your Honor.
But assuming it issued, the judgment issued, but then the parties voluntarily dismissed the case, is that, no, we're done. Forget about it, we're, case over. What effect does that, legal effect does that decision by the land court on a case that no longer exists have?
Well, first it would have to be vacated, Your Honor, but even assuming it was vacated, at a minimum, then there would be a determination by the land court, unappealed, that this was the legal status of these lots. But that's not what happened.
No, I understand that. I'm just trying to get a sense as to what, again, force and effect in a vacuum a land court judge's decision had. Because that's effectively what it seems to me this was.
Yeah, well, this went to judgment, and no party contests that it went to judgment, and it was unappealed.
Gotcha.
So the parties, including the appellants, accepted the application of the land court's judgment to the facts presented. So what we have in reality is an unappealed decision of the land court that has decided unequivocally that the subdivision contemplated in the settlement agreement is illegal. The trial court itself agrees with that premise. The trial court said in the order amending the memorandum in order for entry of judgment, and I'll quote, in Mr. Fowler's letter, plaintiffs argue about the continued viability of a plan that was attached to the settlement agreement. That plan assumed a lot reconfiguration that did not prove viable. That's the trial court's finding in this case. In
The trial court, and I know maybe not much time left, a throwaway argument, but what is the basis for saying that the Chief Justice of the trial court doesn't have the authority to designate justices? I can think of two people who are sitting up here who have been designated interdepartmentally as former members of the trial court on more than one occasion. And I hate to think that some poor person sitting in state prison somewhere illegally on my end.
It could not possibly constitute reversible error, and I do not advance that position on behalf of the defendants.
So on the 93A argument, you seem to be arguing that certain documents marked, I think by your client, but in any event as inadmissible, but have been included in the record should not be part of the record. So either the documents are in the record or they're not in the record.
They're clearly in the record. The argument was premised upon admissibility. It's clear, quite frankly, from our review of the record, that the trial court accepted those for purposes other than liability, for purposes of intent. And quite frankly, at this point, the defendants would concede that the trial court's adoption or acceptance of those documents for purposes other than what would be prohibited with regard to settlement communications would render that issue moot.
Okay. Why did the judge abuse the judge's discretion in allowing the motion to amend to add the 93A claim? The abutters argue that your only argument is futility. Looking back at your brief, I see like a sentence that says it was futile. Is there any other argument you make?
No, Your Honor, and that argument is premised really exclusively on the fact that the settlement agreement itself, from the defendant's perspective at the time, is invalid and unenforceable, and therefore any 93A decision that could issue based on the failure to effect the subdivision was not viable. The bottom line is, the summary position would be, no party has compelled the subdivision. Everybody has backed away from it. The abutters, Schreiber, the bank took no position. The LLC took that position, and the LLC got saddled with liability for breach of contract, breach of covenant of good faith and fair dealing, and 93A. It's never happened. The only thing the LLC ever did was take the position that it shouldn't happen, and it was proven right at the end of the day.
So just on the assignment of the judge, you say the impropriety of the assignment order affected the outcome of the Superior Court case, and I don't understand how.
So I believe that goes back to Justice Brennan's question. From my office's position with regard to this appeal, we have just been engaged to handle the oral argument. We do not perceive that as possibly being reversible error.
Okay.
Can I ask one other question, just because does it matter to our decision-making why the parties opted to have the land court litigation continue, notwithstanding the existence of the agreement?
No, Your Honor, I don't believe it does. That's what the parties agreed to. I can understand that the record presents nothing more than a head scratch on that, but I don't believe it is outcome determinative.
Thank you.
Thank you, Your Honor.
May it please the Court, Joel Fowler for the plaintiffs' appellees. I think the bulk of the appellant's time was focused on the, on the challenge to the summary judgment decision. I want to start briefly with the 93A trial and judgment. I think it potentially short circuits the rest, and then I will move on to the summary judgment decision. The decision of the trial court with regard to the 93A was after trial with findings of fact. So any reversal of that judgment would require, essentially, it would be a different standard. It would require a finding that the factual findings by the trial court are clear error. So it's not merely a question of whether, it's not a de novo standard as in the summary judgment decision. It's a question of whether the trial court acting as a fact finder got it right. The appellants argue that essentially they should have been allowed to present their impossibility, frustration of purpose arguments. They ultimately were. We had a trial. The judge, again, acting as fact finder this time, determined there was no justification for the defendant's actions.
Right, but this seems like the basis of his entire argument was that they were supposed to end up with a legal two-lot subdivision,
Yes.
and that they didn't get that, and they can't get that. So why is he wrong?
He is wrong. That was their choice. They did end up with a two-lot subdivision, or they ended up with the ability to get a two-lot subdivision. They, as the heart of the agreement was that the defendants would receive a special permit allowing the subdivision. That's what the agreement was. There's nothing, that's what the agreement was. So, and that's what they got. The special permit was issued, the appeal period ended, and that's when it triggered the settlement agreement being a final enforceable contract.
Aside from it maybe having had the benefit of avoiding lots of litigation and a fair amount, I would imagine, resources, financial and otherwise, poured into this. Any hint as to why the parties didn't clue in the judge before the judge sat down and spent time writing a decision that's created all of this?
I wasn't counsel at that
Weren't-
time.
okay, so-
No, my understanding is that the concern was, and I believe this was a concern on the part of the defendants, the concern was if they notified the land court judge that they had a settlement agreement, then land court judge would stop, put his pencil down. I think that's probably correct. And that if the settlement agreement was contingent on there not being an appeal of the special permit. So the concern was they tell land court that we have a settlement agreement, you can stop working, then someone appeals the special permit, they don't get it, the deal falls apart, and then they've lost however many months. I think that's the reason. I don't know that it's determined, I don't think it's determinative to this case, but I believe that is the reason.
So is he correct that the merged lots 110 and 111 are not legal?
I'm sorry?
Is he correct that the now merged lots 110 and 111 are not legal, or is not legal? I don't know which one it is.
I don't agree with that. I mean, I think that gets into very much into the weeds of very complicated
I know, but I have two parties who are in front of me telling me that what it currently exists is not legal and what currently exists is legal, and I'm trying to figure out how I'm supposed to decide which one of you is correct.
Well, I think what currently exists is legal. I don't think there's any dispute about that.
Okay, so you say so, and he says, no, no, you're wrong. Yes, you are. No, you're not. No, you are. No, you're not. And I'm not in kindergarten anymore, so how do I evaluate which one of you is correct?
I don't think that the defendants argue that what exists is not legal.
Well, he just literally said, no parties compelled the subdivision into this lots 1 and 2, and he said lot 110 is not valid, and that the only way that the abutters get paid is if there's a legal 2-lot subdivision, and there's not.
Well, first of all, I disagree with the assessment that the only way anyone gets paid is if there is a two-lot subdivision. There remains, there remains 2 lots. They're just configured differently than the way the settlement agreement contemplated. There are 2 lots. There's lot 109 and there's the combined lot 110, 111.
And is the combined lot 110, 111 not legal?
It is legal. And there's no dispute. I don't believe there's any dispute. The combined lot 110, and that was the upshot of the land court decision, that 110 and 111 are merged, 109 is legal buildable lot. Ultimately, PITSICK finished construction of lot 109. That's a legal house. It has a certificate of occupancy. That's in the record. 110 already had a house that the land court recognized. That's merged with lot 111. Lot 111 is not buildable in terms of an additional lot, but that's essentially the same result that the settlement agreement was designed to achieve was achieved by the land court decision. And the plaintiffs very early, very clearly said to the defendants, if you would prefer to take the land court decision and simply build on that because it arrives at the same result, 2 buildable houses, 2 houses. That's the same result. If you would rather go that route, we will not stand in your way, we will agree. And that is what they ultimately did. As part of our agreement, we acted in good faith, the defendants did not.
So, but he says, well, if we're getting into good faith, then we get a jury trial on the breach of contract. What do you say to that?
Well, if there is a requirement, well, no, because the court was correct in allowing summary judgment. I do want to separate it out. The initial point I was making is, he was not entitled to a jury trial on the 93A claim. He had a trial on the 93A claim. There were factual findings on the 93A claim that included bad faith. It included a lack of justification for breaching the agreement, and it included findings that engaged in extortive conduct to try to manipulate the situation to get a better deal than what the contract allowed. Those are all findings of fact made by the trial court as fact finder. There really is nothing in the defendant's briefs that call those into question as clearly erroneous. They're based soundly on written emails that were entered into evidence at trial.
Right, but he seems to be arguing that maybe they shouldn't have been entered into evidence.
I think he conceded in oral argument here that those were accepted, were properly admitted. They were admitted for other purposes than the improper 408 purposes. Essentially, what those emails were was the defendant engaging in a 93A violation. So they had to be admissible, and I think the court was correct to admit them, and I think there's a concession now that the court was correct to admit them. So that was a finding, factual findings by the court that there was no justification for the defendant's actions, and it was extortive, it was a violation of 93A. Moving on to the summary judgment, I will point out, if the court affirms the judgment on 93A, we're talking about the same damages. So regardless of what the court does on the breach of contract claim, if the court affirms the 93A claim, there's nothing substantively that should be disturbed in the judgment.
If we conclude you are correct about the 93A claim, do we need to reach the breach of contract claim?
I don't know that you need to, maybe as a technical basis in terms of how the judgment reads. It wouldn't substantively affect the rights of the parties. But I will move on to the summary judgment argument.
But before you do that, you say that adding the 93A claim was not futile because the count was destined to succeed. I mean, obviously, that's why you brought the claim, but how, at the time of the motion to amend, was the trial judge to have known that? Like, what?
Well, maybe I'm over-arguing it, but I think at the very least, it had a possibility of success. It ultimately did succeed, and it was not futile. I mean, I think we can look with hindsight and say it was not a futile act to to add a claim that was successful. I guess that was the point I was trying to make. With regard to the summary judgment, I think there's no question PITSICK was required under the contract to pay $80,000. They did not. That's a breach unless they're able to come up with some justification. The justifications that they've raised in their appeal are impossibility and frustration of purpose. I'd say impossibility we can just take off the table. It was not impossible for PITSICK to pay $80,000. They got what they asked for. Whether it was ultimately as valuable as what they wanted, they got what they asked for. They could pay the $80,000. Actually, the lender was earmarked to have $80,000 ready to pay, was sent an email saying they stood ready, willing, and able to tender the funds, but for the legal dispute. So it wasn't impossible. So we get to frustration of purpose. That's, in recent years, became a more hot issue with COVID. Different things, different contracts were questioned based on people not getting what they expected to because, hey, there was a pandemic. Even that is a heavy lift and has been found to be in the caseload that has arisen since the pandemic. However, this is not that situation. There actually is no unforeseen circumstance. The circumstance is the land court, which had fully briefed papers regarding a permitting dispute, rendered a decision. Presumably, that ultimately appeals were dismissed, and that became the final decision. Presumably, the land court was correct And then all the land court did was correctly apply the law to the facts as everybody knew them. Now, if people had different predictions as to where the land court was going to come out, that's not the type of unforeseen circumstance like a governor's order shutting down the state. That is not, the fact that a land court might apply the law to a set of facts is not an unforeseen circumstance. But I would also urge the court to look very closely at the contract, because, I mean, the law is that it needs to be the type of unforeseen circumstance that the party trying to get out of the contract could not have foreseen, could not be expected to bear the risk of. And I'm going to, Section 4.7 of the contract says, in entering this agreement, each party assumes the risk of any mistake. This agreement is intended to be and is a final and binding agreement between the parties, regardless of any claims of mistake of fact or law. So this was a mistake, essentially a mistake of law. PITSICK didn't think the court was going to determine that this was what the law was. It was wrong. It was a mistake. But they built that into the contract. Well, if we're mistaken, we bear that risk. Additionally, the contract in 5.1 says this agreement shall be binding upon the parties in resolution of all matters at issue in the litigation, and shall supersede in force and effect any judgment or order issued by the land court on the parties pending motions and cross motions for summary judgment in the litigation, but shall not affect the agreement for judgment described above. So that's, I see my time is coming to an end, but that the parties expressly said, no matter what the land court does, this is still in effect. And unless there's questions, I will accept that my time is up.
Thank you very much. We understand your arguments. The case stands submitted. We'll take about a 15-minute recess and be back to hear the final two cases for today. Good morning again. We're continuing our list today, September 8th, 2025. The next case up is 2024P0651, Department of Children and Families in another versus Mother in another. This case is impounded, so we will refer to the parents, mother or father or child, and not use any names, please. And in case you weren't here earlier today, 15 minutes per side. There's a division of time here. Attorney Gallup will have 10 minutes on the appellee side, and Attorney Shokier will have 5 minutes. And with that, we can proceed.
Thank you. Good morning. May it please the court, Roberta Driscoll-Weiss on behalf of the appellant mother. And I'm here today, Your Honors, to ask that this panel consider what is required when a litigant in a child welfare proceeding is determined to be incompetent to assist counsel and a guardian ad litem is subsequently appointed for that individual. That was the case here. Mother was determined to be incompetent pursuant to a 15B evaluation that was done in connection with a criminal matter, and that evaluation was brought, or the results of that evaluation were brought into the juvenile court proceedings when her attorney asked that a guardian ad litem be appointed for her.
Can I ask on that, was there an actual competency determination in the juvenile court? And if so, is a report from a different court department a sufficient basis to do that, given particularly the fluidity of competency or lack thereof? That's a really long question. It's in three parts, but
Sure.
Sorry.
Thank you, Your Honor. No, there was not a competency determination made in connection with the juvenile court proceedings. However, the court had access to the 15B evaluation that was done as part of the criminal proceedings. The parties had access to that report. The judge was able to review that report, and in discussing the circumstances, made some commentary that mother was clearly very limited and very impaired. And at the request of mother's then trial counsel, agreed to appoint a guardian ad litem for mother. And at that point, much discussion ensued about what type of guardian ad litem would be appointed and what that individual's role would be. And counsel for DCF at that point said, certainly, to anticipate appellate issues down the road, we would have no objection to a guardian ad litem to assist with legal rights, essentially, is I think the way that the DCF attorney phrased her assent to the request for a guardian ad litem. And then the court engaged in this discussion about the difficulties in assigning someone for that purpose, that there were not very many people who could accept such an appointment and act in that capacity. And the judge at that point said that she would appoint an attorney for that, or strike that, I apologize. The court indicated that it would appoint a guardian ad litem on the issue of the legal rights. What was ultimately appointed was a guardian ad litem next trend for diminished capacity. And that individual happened to be a former DCF social work supervisor. The record is then utterly absent of any indication that this individual engaged in the activities that she should have, which were to stand in the shoes of mother and assist mother's trial counsel with the defense of the accusations against her.
Was the judge made aware at any time that the guardian ad litem was deficient in that way?
I don't believe that she was, Your Honor, and I think that that's part of the problem here, is I think that there was and continues to be a real lack of oversight of rules and structure when a guardian ad litem is appointed in these circumstances. As far back as 1986, the Supreme Judicial Court recognized that a guardian ad litem is one who is appointed by the court to represent a person, and that's the phrase that the SJC used, to represent a person who's not legally competent to represent himself in a matter before a court, he is considered a special type of guardian and an officer of the court to prosecute or defend on behalf of another person a suit or matter to which he is a party. And I think it's clear from the record that that's not at all what happened here. There's no indication that this guardian ad litem, first of all, perhaps even recognized that that was her obligation, because there's, as I say, very little structure and routine that goes along with these appointments. But there were affidavits that were included in the record appendix from trial counsel that this guardian ad litem did not make any efforts to stand in mother's shoes.
Do we start from the presumption of the fact that it was done properly or done improperly? I understand that there was evidence raised after the case was concluded from, as you say, by affidavits to say that things weren't done the way, arguably, the way that they could have been done or should have been done. But how do we address the correctness or incorrectness of what happened here where there was no contemporaneous issue raised for the judge? I am having trouble getting past that.
Yeah, I understand the difficulty, and believe me, it was. I recognize the difficulty as I was writing the brief. And what I can say is that there are states that handle this situation well, and I would argue better than Massachusetts does. In my brief, I point to the state of Wisconsin, for example, where the appointing court oversees the conduct of the guardian ad litem to make sure that the guardian ad litem is actually adhering to the obligations of whatever that appointment might be. Similarly, in Kentucky, the court oversees the GAL's conduct also and may withdraw the appointment sua sponte if necessary. In New York, similarly, the court oversees the GAL determinations and in certain types of cases. Notably in Nebraska, the appointing court, which has the power of removal of the GAL, is also obligated to oversee the GAL's discharge of his or her duties. And I think what happens, unfortunately, in Massachusetts, because the method in which GALs are appointed, the rules by which they're expected to conduct that appointment, where there's really very little clarity around what these issues are.
So can I ask you, that was, I think you anticipated my question, maybe if I'm hopefully not anticipating your answer and cutting you off, but in terms of the role of a GAL in this sort of a proceeding, is the only source of that the probate and family court guidelines in this 40-year-old SJC case? Seems to...
Probably, and unfortunately, although I will say no, that's not true. I think in adoption of Kirk, which is somewhat less than 40 years old, similarly, there was the court was asked to evaluate the engagement of a guardian ad litem. But I think that's the problem here, Your Honors. I think 40 years ago, the SJC was very clear about what this type of a guardian ad litem is supposed to do. They're supposed to represent someone, stand in their shoes, and litigate or defend on behalf of that individual. And again, that's not what happened here. And I think, this is kind of an unusual, I find myself in an unusual position because the judge isn't necessarily wrong, the guardian ad litem isn't necessarily wrong, because I think they're operating under the process by which courts appoint guardians ad litem, but that process is flawed, and that's what I'm asking this court to review today is that process. And this...
So they're going to argue in a minute, though, that this was waived.
Yes.
And so what's your response to that?
So the doctrine that an issue not raised at trial being waived is not a one-size-fits-all decision. When there's the risk of a miscarriage, substantial miscarriage of justice, then this court certainly has the authority to review any and all issues, whether they're briefed or not, whether they were raised below or not. And if we all accept, which hopefully we all do, that the right to parent your child and to be parented as a child by your parent is a constitutional right of the highest import and significance, then nothing could be more of a miscarriage of justice than for an incompetent litigant to receive absolutely no assistance in that regard when what's at stake is the termination of her parental rights. And I would love to stand here and say, this is what should have happened at trial because then mother could have done X, Y, or Z, and I simply can't answer that question because I don't know what her options might have been at trial. What I could suggest, I believe it was the department who argued that I don't show any prejudice or I don't explain in my brief how things could have been different, but things could have been different. You know, mother was very clearly suffering from mental illness at the time of the trial, but there was and always is the possibility that that can be remediated. And even if mother could not have been found fit or not found unfit at trial, perhaps some step could have been taken to ensure that at some future point, were she competent and were it appropriate, perhaps she would have some sort of contact with her child or some knowledge of how her child was doing. Often in these cases, what parents can get is maybe a card or a letter twice a year from the adoptive family saying, you know, your daughter likes basketball and, you know, water polo or whatever it might be. Possibly that as a last resort could have been reserved for mother, but it wasn't because no one tried to reserve anything for her.
Just, can I ask procedurally, in what context were the affidavits of counsel submitted? To whom and for what purpose? I'm looking at the affidavit of Attorney Broderick and then the affidavit of...
Probably me.
That's your affidavit. Yeah.
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 Again, I recognize that it is...
It's part of our record, is that right?
It's part of the record because I included it as part of the record.
Right.
It's not part of the trial court record, but...
So in terms of that, I guess procedurally, because normally, I'm not suggesting you need a motion for new trial or claim of ineffective assistance or however you do it, but it seems to me that someone needs to assess the even credibility of even an affidavit. Like, we shouldn't be up here getting facts and trying to figure out, well, is this really what happened or not, right? I understand you're in a bind because you got it as it was packaged.
And I have a client, Your Honor, so there's
Yes.
that.
Yeah.
The affidavits were included, and I believe I addressed this in the response to the department's motion to strike. The affidavits were not included necessarily for their evidentiary value, but more to enlighten the court as to what the perception of the trial attorneys were at the time. But I think even if you ignore those affidavits, the one act that this guardian ad litem put on the record was to come into court and to say to the judge, I thought it was important that you know that I met with this mother several days ago and she made threats of physical harm to people. And I think that one act was so incredibly unhelpful to mother, and it absolutely did not need to be said. This was not a case where there was an imminent threat or risk of harm to someone, and as an officer of the court, this is an individual who's bringing that to the attention of the court. This is a conversation that had occurred days previously. It was not mother's presentation on that day was vastly different. And the one thing that she did actually was to harm mother's legal case rather than help it.
I don't disagree with you on that, but I just, again, just as a practical and procedural matter, don't understand how we then take that to the next step, which is to say, we presume that the GAL did not otherwise fulfill, to the extent there even is an appropriate role, that appropriate role. We don't know what she said in the hallway. We don't know what she said in conversations on the telephone. We have no record whatsoever from which to determine what this person did or didn't do, right?
Right, and therein lies the problem, because it should not be that difficult to determine what she did or did not do. There should be record evidence of this individual being in the courtroom with mother, taking a position, if we agree with the Supreme Judicial Court that a guardian ad litem, and again, this is the SJC's language, not mine, appointed by a court to represent a person, the fact that one could not tell on most occasions whether the guardian ad litem was present in the courtroom other than to have her introduced at the beginning of the transcript, she did nothing. And again, I'm not taking issue necessarily with this particular guardian ad litem's behavior because perhaps no one informed her any differently. But that's the problem here, and that's what I'm asking this panel to address, is that when a parent's unable, due to lack of capacity, to assist their attorney with defending against a case that will result in the termination of their parental rights, they deserve more than someone who sits in the courtroom and holds their hand. And by this record, we simply cannot decipher any action on this guardian ad litem beyond that. And if there are no further questions, I'm out of time, I would rest.
I did have a procedural question. So, so did the mother's attorney withdraw representation, or was it the GAL who withdrew representation?
So mother had an initial attorney who withdrew partway through trial, and a subsequent attorney was appointed for mother at that point.
Okay, that was the part I wasn't clear about. So, because there were 5 more trial days, but there was another attorney appointed.
There was another attorney appointed for mother at that point. And that is the attorney who included the affidavit in the, whose affidavit I included in the record appendix.
Thank you very much.
Thank you.
We'll hear from the department, I think, next.
Good morning. May it please the court. Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the judgment of the lower court terminating mother's parental rights. Mother had due process. She had a right to be heard in a meaningful time and in a meaningful manner. She had court-appointed counsel who moved to limit the exhibits, sought a continuance to ensure mother's attendance, and also obtained the appointment of a guardian ad litem. Now, I'd like to correct some of the statements that my sister made with regard to the juvenile court. The juvenile court has developed guidelines for guardians ad litem. I think that they may be issued in 2014 or 2017, and they identify the different categories of guardian ad litems, what the individual appointed, what the tasks of that individual are to do. So one appointed for diminished capacity is to speak with the adult, consult with the adult's attorney, and to consult or speak with others, if appropriate, who may have relevant information. The diminished capacity guardian ad litem is to help facilitate communication between the attorney and the client, to decipher potentially the client's objectives and help understand the proceeding. And there is no indication to suggest that that is not what the guardian ad litem in this matter did. It's a confidential relationship between the GAL and the client and the attorney. So to ask that the trial court monitor that relationship or those communications in some way would necessarily interfere with that confidential relationship. Additionally,
should there have been a competency determination in the juvenile court in this case?
There was no competency hearing in the
Right.
juvenile court.
That's my question. Should there have been one as opposed to just relying on a report? And I don't remember, I knew at some point, but it was not that recent out of Lawrence District.
So I think that I don't know if there's necessarily a child welfare case on this point. I know that if circumstances arise where the judge might be concerned about a parent's ability to understand the proceeding, the judge could sua sponte, order some type of competency evaluation or hearing, or one of the attorneys could ask for the parent to be referred perhaps to the court clinic to conduct that. Now, from the record, from the docket, it's not necessarily apparent to me that the judge actually had access to that criminal court evaluation. It was referenced in transcript of hearing, and there is one docket entry that says something like, I think district court papers received, but we don't know, what those papers are. But it seems as though all of the attorneys, operated from this kind of basic understanding that mom needed some type of assistance to help her participate and communicate with her attorney.
It does look like the transcript said, the judge says, I viewed the competency evaluation. So I'm looking at transcript 187.
Okay.
Oh, sorry, that's the department. I apologize.
Yeah, I thought it was I thought it was circulated between the attorneys.
Nope, you're right.
And
Sorry.
then representations were made to the judge. And I guess, the point is here that there would be no change in outcome. Now, I guess to also address the issue of waiver, I would suggest that the substantial miscarriage of justice standard has not been applied in child welfare cases. We have a footnote in Care and Protection of Doretta, which says that the cases in which that standard is applied for an issue that has not been raised below are criminal and quasi-criminal cases, such as sexually dangerous persons or civil commitments, where the standard in those and the criminal cases is proof beyond a reasonable doubt. Now, if this court still would like to reach all of these issues and find that, they are relevant and have not been waived, we still don't have a change in outcome.
So just to pause for a moment, though.
Sure.
But how is this, wouldn't this be waived basically every time because you have a GAL who's not doing what they're supposed to be doing, and then you have a parent who's not competent? Like, who would raise this? Unless the judge sort of discerned something on their own.
Well, we don't know that the GAL didn't, we don't know what the GAL did or didn't do, and I would say that it's on the trial counsel to raise the issue if perhaps communication with the client, once this person has been appointed, and communication or deciphering of objectives is still hindered, to bring it forward before the trial court. But for the trial court to kind of monitor that relationship, it would be, perhaps overly burdensome, because now you're potentially interfering with the attorney-client communications. So I would suggest that it would be upon the trial counsel to raise the issue rather than have the judge, check in. One of the things, though, that the guidelines do identify, however, is that a GAL appointed for diminished capacity can provide the trial court with a report on a specific issue if the judge makes that part of the order. So there is some type of monitoring already in place within the juvenile court guidelines.
Those guidelines are not in the record anywhere?
Pardon?
Are those guidelines in the record? I missed them, or are they not here?
The guidelines, I don't
Juvenile
know.
court guidelines.
I don't know if they're in part of the record.
All right, I'll look again. I don't remember, I looked for them and I don't remember reading them, but I'll look again.
Oh, they're in my sister's addendum.
Okay, thank you.
So the issue here is that we still have a parent who abandoned the proceedings mid-testimony, from which the judge took an adverse inference. And then we also have just a significant amount of evidence of unfitness and due to not participating in the action plan, not visiting with the child for extended periods of time, and also just the fact that when she was testifying, it was apparent to the judge that her mental health remained unaddressed. And I would, with regard to my sister's request that this court develop some type of parameters or rules for guardian litems in juvenile court, I think that that's kind of more in the realm of something that the Supreme Judicial Court Rules Committee does rather than through a decision. So I don't know if that relief is appropriate. If there are no further questions, I would rest on my brief.
All right, thank you. We'll hear from the counsel for the child.
Good morning, Your Honors. Richard Shokar for the child. The Appellee child requests that this court affirm the termination decrees and orders. My client, as the SJC has ruled, has an unqualified right to permanency. In this particular case, I hope to address some of the questions that were raised earlier. As to the procedure, there were other avenues to go. There could have been a Rule 59A motion that was filed. I don't know if a 60B motion is even applicable because I don't. The juvenile rules of civil procedure don't apply to termination proceedings. And more importantly, as to these sort of theoretical rights that mother would have, which I'm assuming would be substantive due process rather than procedural, there's really no case law or any recognized statute that would address any of these. The guardian ad litem's appointment was to assist mom in assessing the trial process. The idea that she's standing in her shoes is sort of self-evident because the argument is pretty simple: oppose the termination trial. The fact that mother is incompetent, and because in care and protection proceedings, as opposed to criminal matters, there's not the full panoply of constitutional rights. This seems to be kind of a moot point because...
I mean, isn't the problem here, though, if the mother's not competent to be a participant in the trial, the mother's not competent to parent this child? So is the issue that mother needs to get treatment?
The issue at trial is what the statute says. Is she unable, unwilling, or unavailable to parent the child? So the practical reality of this case is she going home with mom that day? And the answer, I believe the evidence fully supports no.
So I don't know how I missed it, but just so we're clear, the not guidelines is a standing order of the juvenile court regarding appointment of guardians ad litem among other and investigators, which actually didn't exist at the time of this trial, unfortunately. It looks like it was October of 24 and this trial was January 24? Okay. So it's not even a situation where we considered, was this order actually followed? Was it violated in some way, which seems to me might inform.
But more to the point, again, to the practical reality rather than the quantum aspects of this, is this child who is, I think she was 4 years old at the time of trial, now she's 6 years old, she's been living the majority of her life with a kinship pre-adoptive placement, she's happy, she's doing very well, and as opposed to the more, I guess, Newtonian reality of what her life was like with mother, which was being the recipient of some physical violence against her, which led to the removal. These things are tied integrally to mother's mental health, which she did not address, could not address, or refused to address by the time of trial. Given that reality of this case, the question becomes, what would this court imbibe a potential guardian ad litem in the future with in terms of the magical powers that would be necessary to, I guess, become the defendant in the case. And that is something that I don't think any of these courts really has the ability to address fully. There could have been some procedural safeguards, possibly, but it would have never affected the outcome of the case. Mother simply abandoned the proceedings. So if you don't have any further questions, I would rest on my brief, and I would again respectfully ask that the decrees be affirmed.
Thank you very much.
Thank you, Your
The case
Honors.
is submitted. We'll hear our fifth and final case for today, which is case number 2024 P1079, Joyce Micholitis as trustee of 3 Dana Avenue Realty Trust versus HHC1 Arnold LLC.
Good morning, Your Honours. May it please the Court. My name is Damon Seligson, and I represent the appellant, Joyce Micheliditis. The crux of the appeal, Your Honours, is that the trial judge was clearly erroneous in failing to accept the defined disputed portion of the property that my client has claimed by adverse possession. There was a straightforward presentation of evidence. 2 witnesses were presented by the plaintiff. Joyce Micheliditis, the owner of the property at 3 Dana Ave, and her daughter, Urini Micheliditis, who had lived there during the period of time in question. During the trial, and this is an adverse possession case, the case law is established what the plaintiff's burden of proof is, and the counsel and I agree on that. There's no dispute on what we have to show.
Excuse me, do you agree that this was a Rule 14 trial?
Yes, Your Honor.
All right, so even though there was not a written stipulation that I could find, was there actually a written stipulation filed?
There was
just an oral agreement.
There was an oral agreement with the judge pre-trial that it would be a Rule 14.
All right. But so you're not disputing, because as I read the rule, it requires, I mean, I guess you could read it otherwise, but it seems to me to require actually a written stipulation, not just an agreement. But you're not disputing that the standard of review we have here is on Rule 14. This is a Rule 14, Land Court Rule 14 trial.
I am not disputing that, Judge. What we take issue with is that the trial judge had a problem from the get-go that there wasn't a survey that defined the disputed portion, and then from that, everything seemed to fall down.
Right, so just
the judge required that the judge did not say that absent a written survey, I could never find the boundaries. What the judge said is, I have never seen a case in which there is no written survey, there isn't one here, and the other evidence is not, that I credit, does not identify what that area is. Is that, am I correct about that?
That's correct. And so the difference in this case was that this wasn't just 2 property owners just sort of fighting over what was the disputed portion of land. The neighbor at 7 Dana Ave, the Appellee, purchased the property in 2018 and went through an exhaustive Article 880 permitting process, and in that process prepared plans, drawings, submissions to the Boston Planning and Development Agency, to the Boston Zoning Board of Appeal. So there were documents such as that, such as we've included at exhibit in the record appendix at page 43, which is not very legible, and so I have a larger portion. So the configuration of the properties were very easy to decipher from the evidence that was presented at trial, from the stipulated exhibits. The day before trial, we had a...
Counsel, when you use the word decipher, it always makes it seem to me like it may not be that easy on its face. But let me ask you a different question. Do you agree that, although you mentioned in your brief, that a view is not evidence?
It is not evidence, okay. Correct.
All right.
But just help me out here, because I understand that you do agree, and they agree, that the garage was over some property line, and that was adverse possession in favor of your client, right?
That's correct.
And what I couldn't figure out is in this area of this trees and scrub, was the garage over, is that the line the garage was over, or was the garage over a different line?
So if I may, this is in the record appendix. I apologize. We all went to law school. I'm so sure everyone's eyes are as bad as mine. But this is the garage in green. This is the disputed area. This is Dana Ave. There's a light post.
Is the garage 2.5 feet over onto their property?
The garage is at least a foot over onto the property. What we were saying is that that yellow line is the disputed area, that the judge saw that at the view, notwithstanding that it's not evidence, but he saw it at the view. So there was some context from which he could take when he was listening to the testimony and seeing the exhibits that were presented and the photographic evidence. This is a straight line.
So let me ask you this then. So you can put your exhibit down. Yep, thanks. Since you were looking for a declaratory judgment, in a simple declarative statement, what should the judge have stated? The plaintiffs have established adverse possession to blank. Fill in the blank.
He could have said that there is a chain link fence that runs along 3 Dana towards 7 Dana.
That may have been moved back and forth, or not this one?
It's never been moved, Your Honor. It's been taken down, but it's been replaced so that someone could access one of the properties. So it runs along 3 Dana towards 7 Dana. From that point, 2.5 feet, and then all the way along the property line.
Wasn't it about 2.5 feet, or maybe 2.5 feet here, but a little bit less there? And that's, I think, what the judge had trouble with, and that's what I'm having a little trouble with, is how, without a definitive area, how anyone can declare anything definitively.
Because you could take the 2.5 feet and you could then track with other landmarks. There were 3 trees along the property line. So when 2.5 feet from where that chain link fence ends, 2.5 feet forward, then along through the middle of those trees to the garage, that was to the property line, which was staked. So
are you saying that that fence that ran along along the sidewalk, are you saying that 2.5 feet of that fence was marked to the property line, or where did that fence end? Because I couldn't figure that out.
that fence, if there is a trial exhibit number 26, which is at page 52 in the appendix, shows that fence running up Dana Ave past a utility pole.
Right, I see
and then it sort of meets the trees. If you have a look at the orientation, it meets the trees. You take
I'm not being fresh. Does it meet the trees, or does it sort of meet the trees? Because if it sort of meets the trees, then how does the judge find, are they declaring that that area is sort of adversely possessed?
I'm saying that here today. The judge saw that at the view, and there was testimony about that, Judge Brennan. That end of that fence, that pole, that stanchion that ends the fence.
Yep.
My client testified that 2.5 feet from that towards 7 Dana, down the property line through the middle of those trees, was the disputed area.
Okay.
So you're saying if I were to stand on that, in front of that fence, looking back towards the garage would be a little over to the right. The garage would actually be still more to the left. Like, in other words, looking straight back from that fence post, I'm going to be looking at part of the garage.
Yes.
Okay.
And so once you've had a view, even though it's not evidence, and then there are photographs, and then there are plot plans, the ability to establish the defined area, it doesn't have to be exact. The cases say it needs to be with sufficient certainty. Sufficient certainty. The judge was getting tied up with testimony about a chain link fence, a chicken wire fence, that had existed at some point along the property line, with this chain link fence that was never part of the case. It was simply used as a landmark to establish where the 2.5 feet starts.
So you're saying the judge got caught up. Let me ask you this, hypothetically. If you tried this case to a jury, and the jury went out, and amongst themselves, we don't want what to say, but geez, it could be that, I don't know, it could be that. Honestly, I think I get a pretty good idea, but definitively I can't say, and then they come and bring and they deliver a verdict for the defendants, okay? What's your appeal on that, since that's the standard we're supposed to use? It's as if a jury decided the case on this Land Court Rule 14. It wasn't convincing enough, in other words. Yeah, you could say, geez, if they just remembered what they saw in the view and they kind of listened more carefully, they probably could have figured it out, but if they didn't, what are we left with?
I think I would be here making the same argument, Your Honor. Respectfully, I think respectfully, the trial judge didn't accept that this was a land court case for adverse possession without some type of a survey. Seemed to be caught up on that from the get-go, and that seemed to color everything that my client testified and her daughter testified, and the photograph showed later that there was this ill-defined area that he would not accept, and that seemed to be the erroneous standard that I'm arguing seemed to make everything fall down, because the period of time at issue here was 1984 when my client purchased the property to 2004, 20 years later. Nobody rebutted what the use was. There was no testimony about the use wasn't what we alleged, because there was no evidence, there was no witness that had seen or been to the property during that period of time. So what the judge really was focused on was the fact that we had failed to define the area. And then from there, he wouldn't sort of accept what the use was in that area. And that was the problem. And that what I respectfully argue was the clearly erroneous aspect of this presentation of evidence. In hindsight, should we have had a survey? Would it have changed the outcome? I think it would have. But we presented enough evidence in the plans and the photographs and testimony, and it wasn't some hard to figure out logistical landscape. It's a rectangle on two lots that abut one another from the street to the garage.
But it's a significant point where exactly that rectangle is from side to side. It could be a phase shift one way or the other and make a difference based on the type of use that was alleged here for periodic placement of card tables or a short period of time placement of a hammock or a bird feeder or those kinds of things, and maybe later maintenance. But here the judge said, clearly, nobody seems to be able to tell me whether it goes a foot or 2.5 feet past this line that everybody acknowledges is adjacent to the record property line. The judge is not required to accept the unrebutted evidence. He's required to make credibility findings or sort through what the evidence is. And I don't understand how that finding, given the variable pieces of evidence that were introduced, is clearly erroneous. I can understand where you might think it's not, you'd prefer to have a different outcome. But clearly erroneous is a different thing.
I understand, but I think that the testimony from Joyce Micholitis was that it is 2.5 feet from that landmark. Her daughter said it was 2.5, perhaps 3 feet, but it was never.
Right, but I mean, if you look at the record appendix at page 396, the judge accepts that. He says the plaintiff consistently said, we're looking for 2.5 feet, but his problem was there was no consistent evidence of occupation of an area that measured 2.5 feet from the property line. Then he goes through the problems with each piece of evidence.
I understand that as well, Your Honor. Respectfully, I believe there was testimony about use of the property from 1984 to 2004. There was testimony about use of the property after that by the defense, that they cleaned it up after the owner, DBS Development, purchased it in 2010, I believe. That was not relevant to the analysis. The analysis was, had Micholitis established adverse possession from 1984 to 2004? And respectfully, we believe that the evidence was there, that they used the property, that they maintained it, that they landscaped into that tree line, that they used it for Greek celebrations because they're a proud Greek family, and that came up all the time. That there were these.
Wasn't the judge's finding on that is the very definition of sporadic use to say, well, we had Easter parties there?
The parties were sporadic.
Is that clearly erroneous, that finding?
The parties were sporadic, but there wasn't, I think the clearly erroneous part was if you just itemize one portion of the use and use that as significant of everything else, then that's clearly erroneous because there wasn't just sporadic use for events, there was maintenance, there was use of a hammock, there was landscaping, there was mowing. So if he just uses that as the definition of use, then that is belied by the evidence.
Could I ask one other question? We've been talking about clearly erroneous fact-finding, and I understand your arguments about that, but do you have a case that says where there's an agreement to try the case under Rule 14, the judge is providing an explanation that includes factual findings? Does that provide you a basis to make a challenge to those specific facts? Or are you still limited to the Rule 14 standard of review?
Well, we agreed to the Rule 14 standard of review, Judge Hand. I don't have a case that stands for the other proposition. In all honesty, I don't. I see my time is almost up. If you have any other questions for me, I'll gladly answer.
Nope, I think we understand your arguments. Thank you.
Thank you very much.
Good afternoon, and may it please the Court. I'm Michael McDermott, counsel for HHC 1 Arnold, which is the record title owner of 7 Dana Avenue and the area of land that includes the disputed area. HHC requests that the land court's decision be affirmed because it, as the record title owner, shall not be dispossessed of its ownership interest except upon clear proof, with the acts offered by the adverse possessor strictly construed, and reasonable inferences shall be made in HHC's favor in this Land Court Rule 14 appeal.
So we have a preliminary issue that I think is troubling all three of the judges on your panel, which is that you agreed to proceed under Rule 14, but then the judge makes express factual findings. So what do we do with that? Do we apply a Rule 14 standard, or we just say, well, the judge made these factual findings?
Yes, so first regarding the agreement for Land Court Rule 14, within the record appendix, and it's on the transcript, I just have the transcript notes here, it's transcript page 2, day 2, 5, and day 2, 106. There's discussion about the parties' agreement for a Land Court Rule 14 trial, referencing emails that were submitted to the court as that evidence that the agreement had been there, as well as the fact that the parties submitted the Land Court Rule 14 proposed verdict form stating that they had agreed, it was amended by the court, and then that's what the court checked off. So those were the writings for the Land Court Rule 14. With regard to the court's statements from the bench, I think that they're a form of dicta. The judge, when he comes on the bench, says he likes to do this to provide people with additional information about the ruling that he came to. Those are not evidence. Those are statements by the judge. The Land Court Rule 14 verdict are the findings, and the evidence of the exhibits and the transcript from the trial testimony is the evidence that's being looked at, and which is to be looked at with all reasonable inferences in HHC's favor, looking at any combination of circumstances and any combination of the facts for this appeal.
Well, what if there was just he does this procedure, and this is not this case, I get that, but we always have to think about the next case as well. And let's say that his client did put in a plan, and in the first thing he says is the plaintiff did not put in a plan, and that's just dead wrong. Okay, but you're still saying we apply the Rule 14 standard and we ignore this stated error.
Yes, here I think you would. It goes to the analogy of a jury room. The jurors in the jury room could come up with something incorrect. We would never know because it's in the jury room.
Right, but we do know, that's the problem, and that's why we're not happy.
That is the challenge, I understand. But that is the standard that's applied here, and you go back to the facts. So if the judge came out and found in the verdict form that there was not a defined area, there was no actual use, checking no, like was done here, but the appeals court, looking at all the facts on the record, all of the evidence, even with inferences in HHC's, or at that point, the appellee's favor, came to a determination that there was an error and that there was an actual defined area, that check mark was in the wrong spot. That would be the the basis for a clearly erroneous finding, not the dicta of the judge's statements. one thing to keep in mind, we were very focused and remain to be very focused on the defined area, whether or not there was a plan or not. But that wasn't the basis of the judge's entirety of his statement or in the findings here. 5 of 7 elements were found in favor of HHC, not in favor of the plaintiff. In an adverse possession case, each and every element must be found in favor of the plaintiff, of the party claiming adverse possession, for adverse possession to be granted, for title to be moved, and this is strictly construed from the record title holder.
How do we even get there? And that's, I guess, what I'm having some trouble with. Is it seems to me internally inconsistent to say they didn't define the disputed area, but on the undefined disputed area, they didn't prove these elements. It seems to me it could be, well, one or the other. I mean, if you don't have a disputed area, then how do you even reach the elements of what was done with respect to that area?
Certainly in adverse possession cases, especially those that are on summary judgment, and I do not have a citation for me immediately for you, but it is in the briefing where the cases that are cited reference the fact that because a 20-year period was not alleged, I do not reach the remaining factors, and the analysis can stop. Here, because this was a fully tried issue with all of the elements put before the court on the verdict form, each and every one was analyzed. So if this was on summary judgment or a motion to dismiss, it is likely that there could have been a finding that because there was no defined area and no evidence of actual use of that defined area, the analysis stopped. That's not what occurred here. So what occurred here is we do have the benefit of being able to look at each and every element, which means that for this panel, if it were to be a decision that it was clearly erroneous to focus on the need for a plan, and I don't think that that was an error because the evidence is that there was testimony that this wasn't a defined area. And we go through numerous quotations in the briefing from the plaintiffs and that they didn't measure. They started transcript page 26 on day 1. It goes from a couple of inches. This is a quote. Well, no. So it's the disputed area goes 2.5 feet and then it meanders. At another point, it's described as going to the center line of trees. At another time, it says to the face of the trees. Even here in the appellate briefing, it's slightly beyond the tree line. And so we've never had any evidence of what this outside boundary is. We know that it starts at the record title property line, but how far does it go was never established.
But the problem I have with that is that y'all agreed that the garage was at least some over the property line. So let's take for the moment, and you can tell me because I don't remember from the record, but let's assume that the garage, like the whole wall of the garage was over a foot, not 2.5 feet, but over a foot. Why wouldn't that cover the whole foot, right? Because that, I mean, that's how people mow, that's how people, and here you don't, the problem is you don't mow because it seems like it's a scrubby area, which coincidentally there's one of those a couple doors down from me, right? So I have no idea where their property line is because it's just this like bushy tree area that all the kids play in like it's a, 100-acre woods, even though it's, 10 feet across. So, but if the garage is over a foot and most property lines are just straight, why wouldn't that be enough to show that it's a rectangular lot and it's a foot?
So based off of HHC's survey, which was prevented, the garage was over at 1.1 feet at one corner and 0.8 at another corner, and it was stipulated that that was not going to be contested at trial. The title to that area could be conveyed to the plaintiff because it was a structure fully enclosing an area of use meeting the standards of adverse possession.
Which corner was which? Like, was the corner closest to the street, closest to the chain link fence, the 0.08, or was it the 1 point whatever?
So I believe it was the 1.1, which was closer to the street, and the 0.8 that was closer to the rear of the yard. But the reason why that doesn't establish it is because of the standard for adverse possession. So you can't transfer title without clear evidence of that use. And so here, for example, there was testimony about how yard work was done in 3 Dana's yard. But when they created a flower bed in 2019 or 2020, they didn't go up to the edge of their garage. They stopped short. When we look
because the trees are shady.
Well, and that's exactly the point. So because the trees were there, they were unable to enter that area, to use that area, to care for that area, to have parties in that area. The testimony is that when they held parties, which were sporadic, some Greek Easter parties, the tables were set back some from the lilies to not crush the lilies which were approaching the trees, suggesting that they remained in the 3 Dana yard. And the photograph evidence was that the people were standing in front on the 3 Dana side of those tables, again, not entering the disputed area. So although the garage may have an encroachment and was measured, the rest of the uses that were suggested have no bearing on the garage itself. So the garage can't be used as a simple line that's a quick measurement that's being provided, as the front chain link fence running along the sidewalk or a telephone pole can't be used as a quick line. We don't draw and connect the dots between the two. We must have evidence that shows how far into the disputed area each type of use went and for how long it went. And here, this is the other issues that the plaintiff had in this case, in that these uses never reached a continuity of 20 years. They were too sporadic, too intermittent in the area, and never measured. Let's take a look at the hammock, for example. That was something that was much more recent when the plaintiff's daughters were older. It was one hammock line that attached to the tree. The hammock itself was over the yard in the photographs and the testimony, not in the disputed area. So at best, that example is that
So, excuse me, I go back to my question. When you say it's not in the disputed area, if we don't know what the disputed area is, how do we know that? And it brings me back to, and I'm looking at the judge's finding at Record Appendix 378 and 9, cannot define the area. There's insufficient evidence of the area. There's no consistent evidence of the location, et cetera, et cetera. Why is that? Tell me again why there's not a full stop. I mean, it helps you, but
it is a full stop. We don't have to go further. But again, because this was
you're saying even if we go further, it's not there
Right.
regardless. Okay.
Yes, and the argument here is that if you were to find that the judge was in error and that should have been overturned as clearly erroneous, then we have the benefit. My client has the benefit of each and every element having been looked at trial, and you would move to the next and find that they did not establish their burden. Going to how we know something like the hammock isn't in the yard, we did have trial testimony in which it was established that there was a pine tree in the middle of the yard and that the blue section of the playground in the photographs that was there for 15 years, not 20, was in the middle of the yard, and that the area that the playground was relevant to was that the red glider on the far edge side may have had a swing path that entered into the disputed area, or if someone was trying to go around that play swing set, they may have stepped into the disputed area. So using the play set as a guide and the tree in the middle of the yard as a guide, other photographs and testimony were able to be presented that established that the hammock itself was not hanging in the disputed area, it was hanging in the 3 Dana's yard. That when kids were playing on the play set, they were not playing in the disputed area, they were playing in 3 Dana's yard. That when you set the table back to not crush the lilies and then stood on the 3 Dana side of the table, you were not in the disputed area, you were in 3 Dana's yard. Which means that the evidence that was presented at trial was all in the 3 Dana yard. And so now we have a case where the testimony is about a spillover effect. And when you're talking about a spillover effect, the appeals court has said that that is not establishing adverse possession because it's not actual use and it's not open and notorious use. 3 elements of adverse possession are not being established. And that's exactly and precisely what we have here. Sippis v. Safarowicz was a 2009 Rule 128 decision. Russell v. Nixon is a 2003 Rule 128 decision, both of which dealt with analogous factual findings. In Russell v. Nixon, it was a clothesline that extended to a tree in the disputed area, but that's not where the clothes were hanging. It was there for a short period of time. In Sippis v. Safarowicz, it was cookouts, camping, mowing and planting that was in the yard and may have spilled over to the edge of the disputed area. But because those items, the corpus of those items were in the plaintiff's actual property, the courts found that the actual open and notorious elements had not been met. And the reason is because the level of use, the intensity of use, must be so open and so notorious that the record title owner is able to see it and do something about it. And so going to Justice Henry's example of the brush area that's where kids play, that would not be sufficient enough for a neighbor to say, I think they've crossed through the brush and into my property. I should reach out to my neighbor and say that for the 20 years of the kids playing here, that's insufficient, that's on my land, that's not allowed. Here we don't have 20 years of that type of play. And in fact, the 1984 to 1996 period goes right out the window from the plaintiff's own testimony when we get to children's play. The testimony from the now adult child was that there was a chicken wire fence running through those trees that, although flimsy, was sturdy enough to be used as a, quote, backstop when she played soccer. And if the ball went over that fence, she would have to go up and over the fence or around the outside of the fence into 7 Dana's yard to retrieve the ball. Ms. Micholitis, the owner of the property, testified that when she purchased the property, the fence was there. She didn't maintain the fence, she didn't install the fence, and importantly, in the mid-90s, the fence disappeared. Sometime between 1994 and 1996, she no longer remembers a fence being there. That time period is important because she didn't remove the fence. She doesn't remember ever removing the fence, just as she doesn't remember removing trees that have resulted in old stumps in this area. This means that when we get to the exclusivity element, none of the period of time before my client's ownership or their predecessor in title's ownership, both of who testified at trial, were shown by the plaintiff's own testimony that it was not exclusive. Now, in this case, we do have a request for fees that was briefed. I do briefly want to mention that. And it's important because the parties agree on the law here. This is a place where the trial court and the land court justices say this is well-settled, old law. The parties agree on the law, and the facts are what really are in question. But there was no reasonable expectation that on appeal these facts would be overturned, these findings would be overturned. The appeal is focused primarily on whether or not there was an error in the judge's mind about whether a plan was necessary, not how the entire disputed area was used for the continuous 20-year period. So as was stated in ALAN v. Batchelder in 1984, the appellant's case had lost all vestige of merit after the land court judge made his decision. It goes on to say, coupled with the strong evidence built up in favor of the appellee, there was no hope of the appellant for any issue of fact. The judge's decision also contained a discussion of the relevant authorities, all of which had been copiously cited and discussed in a post-trial memorandum. Before he launched this appeal, therefore, the appellant was fully aware of the powerful precedents built up over the years against the appellant's position. There was no reasonable expectation of reversal. The appeal was frivolous. I see that my times have expired. If there's no further questions, HHC would ask that the decision be affirmed and that fees be awarded.
Thank you very much. The case is submitted. We understand your positions, and that concludes our sitting for today. I want to thank our staff for their assistance in accomplishing the sitting. Thank you.